Thanks, Graham. Guys, I'd like to invite Rob from Bartier now, who's going to give us a legal update. So, Rob, it's over to you.
Thanks very much, Rob, and thanks everyone for welcoming me to speak at the meeting tonight. For those of you who don't know me, as Rob said, I'm a partner at Bartier Perry Lawyers in their commercial disputes team and specialise in largely building and construction disputes. I'm just going to hopefully not have a heart-in-mouth moment and share my screen successfully with everybody.
Can I interrupt for 1 second? If everyone would like to, if they haven't already got their view on speaker view, the top right-hand corner, you can choose your speaker view, and that way you can see more of the presentation. Sorry, Rob.
Joe, and Rob, whilst Rob's doing that, sorry, just to say hello, David Crease from Bartier Perry. I was going to introduce Rob. He really needs no introduction. He's a very experienced, notwithstanding his youthful good looks, a very experienced litigator, lawyer, particularly in the building and construction area. I'm sure you'll get a lot out of his presentation. I don't know whether he's got questions at the end. Can I just say to you, a bit of a warning, don't ask him either anything about St George or about Latvia. Don't ask him anything about St George because he's an avid St George supporter, and given the season they've had, you can imagine the reaction you'll get. If you ask him about Latvia, he's likely to sing the Latvian national anthem, so that's not a good look either. So I'll just leave you with that word of warning.
Does he tell better jokes than you, though?
Oh, far better, in Latvian.
Well, thanks, David, for that, I think, very kind introduction. Can you see my screen? Can everyone see my slides? Have I shared that successfully?
Don't forget bottom right-hand corner, share.
Yes, but I have shared so everyone can see?
No.
No, okay, that's a problem.
You'll have to click share my screen.
Yes, and I have done that.
And then once you've got it up on your screen, then the bottom right-hand corner, there we go.
Did that work?
Yes.
Yep.
Fantastic, great, we're in business. All right, I thought I would just briefly share with you a few thoughts that might neatly segue into Mark's more in-depth expose into the role of experts and how important they can be in cases in NCAT and the courts and tribunals. And I just thought I'd touch on a few of the more subtle aspects of briefing experts, when to bring them in, and a couple of ways that you may not have thought that they might come in handy. So first thing I want to talk about is what's the optimal time for briefing experts, the pros and cons. Clients will often have a very strong view about whether they should come in at the outset of a building dispute and identifying defects, especially in the defects cases, or whether they should only be engaged after proceedings are commenced or at the time of commencement of proceedings. Then I wanted to have a little look at experts and Calder bank offers and how experts can be used to assist in setting out reasoning in a Calder bank offer that can make it more effective than an offer that is not backed with detailed expert reasoning, and the things that you have to be aware of and careful about when looking at that issue. And thirdly, can experts assist to make a case against, that should say, work orders? Apologies for the typo on that. And finally, if we have time, I just wanted to run through a tale which might be amusing, which is an actual true story about where I've seen an expert on the other side come unstuck, thankfully to our client's advantage, but it's a salient lesson in terms of being careful both with your expert as a client and also experts making sure that they've got to be careful to comply with their duty of disclosure. So the first issue I wanted to look in some more detail at is when is the best time to brief your expert? Does that happen at the very start of identifying that you've got a problem with building defects, or does that happen at a point in time when you're closer to get serious and start proceedings either in NCAT or a court or defend a matter? Naturally, there's often a period of time before proceedings are commenced where the parties are cognizant that there's a problem, they're talking to each other, and my most common comment from clients is, why spend the money on an expert when we haven't properly explored whether we can resolve this commercially? So I've just set out a few pros and cons. Usually the complaint from a client will come shortly after the expert provides an estimate for his or her fees, and then they start to balk and say, can we bring our expert in at a little bit of a later point in time? I'm not a fan of that. I think in terms of understanding your client's case or how to defend a case, particularly when there are numerous defects involved, it's important to get the expert in at the earliest opportunity. It is a means of identifying all of the issues and making sure that the pleading that you end up with ultimately, if the matter can't be resolved, or a mediation or other form of dispute resolution, is as effective as it could be by having a properly considered assessment of defects and being able to present them in a cogent way that your opposing party can understand, or in fact understanding the intricacies of your opposing party's case. So it will actually save time in the future if the expert can narrow the issues and make your case more understandable, and it will be a simpler case. A building case in any jurisdiction is far from simple, and there are always complicated issues, and they're usually time consuming. So if you can save hours or a day or two by getting your expert in at the earliest possible opportunity, you have the best chance of maximizing the outcome for your case. Adequate time for invasive testing and other forms of assessment of defects that aren't readily visible to the naked eye are also an important element in making sure your expert comes in at the right time. So really, in terms of briefing an expert closer to commencement of proceedings, you can save some costs and in theory apply those resources to negotiating an early outcome. And you then face oftentimes in NCAT and the courts time pressure to meet tribunal and court deadlines, and also missing important issues that may have been uncovered if the expert had been briefed in time, is a pitfall that you would likely not have as much likelihood of being burdened with if your expert is briefed on time. So first point is, in my experience, the earlier you get your expert in to start looking at the problem, the better. The next issue I wanted to have a look at is experts and Calder Bank offers, and the reasoning in Calder Bank offers and how an expert might be used to assist in preparing the content of a Calder Bank offer. For those less familiar with the term Calder Bank offer, it's a written offer which is made on a without prejudice basis and assessed by the court or tribunal at the conclusion of the hearing of the case. The rule behind a Calder Bank offer in broad terms is if the outcome of the hearing is more advantageous to the offering party, that gives the offering party a basis to apply for an indemnity costs order. Again, for those who aren't all that used to terms like indemnity costs orders, a successful litigant will normally be entitled to a general party and party costs order if they're successful or largely successful, which when your costs are assessed usually entitles you to about 60 to 70% of the total costs expended by a party. That can obviously leave a significant sum unrecoverable, even to a party who has successfully proved or defended the majority of the claim. Applying successfully for an indemnity costs order usually entitles the party to 90% or sometimes more of the costs they actually expended preparing or defending their case. So Calder Bank offers can have very advantageous financial outcomes if put together correctly and if the basis is provided for an application for indemnity costs in a proper and cogent manner. So when assessing whether an outcome after hearing is equal to or better than the terms of the offer, which is one of the prerequisites for making an application for indemnity costs, there is more than that meets the eye as to what the court or tribunal will consider. Firstly, if it's a monetary offer, which is the most usual form of a Calder Bank offer, the figure offered must be at least equal to or exceeding the amount the court awarded. Secondly, if an offer is made inclusive of costs, that's for a plaintiff that is, if an offer is made inclusive of costs, for the defendant making an offer that is, if an offer is made inclusive of costs, courts have said that this may entitle the offeror to an indemnity costs order, usually only in circumstances where it's possible to discern whether the damages component can be separated from the cost component. So an offer of $60,000 inclusive of costs can't be said to be on equal footing with a judgment of $50,000. So that's the second important factor. But if those two hurdles are overcome, an application for indemnity costs may be defeated if the reasoning given by the judge or tribunal member differs from the reasoning set out in the offer. Usually when you're making a compromised offer, the idea is to set out the basis for the compromise. And if you've got many parts to a case and you think you've got an ace in the deck and the other parts to your case aren't as strong, your client might be happy with accepting that proportion of the case that reflects your strongest suite. So putting pen to paper about that is a dangerous but also very powerful tool that can be included in a Calder Bank offer. So if you set out your reasoning and the court or tribunal member agrees with that reasoning and you've got your figure right, then you're in the box seat to say to the judge or tribunal member that your client should be entitled to an indemnity costs order because the other criterion of whether a Calder Bank offer will lead to an indemnity costs order is whether it was unreasonably refused by the considering party, by the other party. So sitting down with your expert and asking them what they think about the strength of the various components of the claim can be the difference between making a Calder Bank offer that will be effective rather than an offer that was close but ultimately unsuccessful. So just some food for thought in making offers at critical points in the proceedings. Now, I just wanted to have a look at how experts might be able to assist in making a case against Section 40A of the Home Building Act, which provides a preference for court and tribunal members to make work orders rather than orders for monetary damages, unless certain criteria can be proved against that presumption. In other words, if your client's objective is to receive money because they've lost faith in their builder, that will no longer be enough to convince a court or tribunal to make such an award. The courts have said in a case of Leung and Alexakis, I'll give out case references if anyone's interested, I can send them through by email. But Section 48MA is not in terms mandatory. Rather, it's a factor to be taken into account in the exercise of a discretion about what orders should be made to resolve a building claim. Being expressed as a preferred outcome, it operates in the manner of a presumption. That is, unless the facts of the particular case make it inappropriate to order rectification of the defective work by the responsible party, an order should be made in terms that give effect to the principle. In another case of Kermond Homes and Marsden, Section 48MA is directed towards the remedy or outcome to be provided by the court or tribunal where a claimant establishes the responsible party has carried out defective residential building work or specialist work. In this sense, it's not properly described as a presumption, Rather, it's a remedy to be preferred to other forms of order which the court or tribunal might make. In the second reading speech, where the Minister for Fair Trading made clear the purpose of the amendment was to, 1, prevent a homeowner from unreasonably refusing a builder access to a building site to rectify defective work, 2, permit a builder to return to carry out necessary rectification work if they are willing, and 3, to support the timely and cost-effective resolution of disputes. That is, in deciding what order should be made, a court or tribunal may consider whether there is a reasonable basis for any objection raised by the homeowner to the builder being permitted to rectify the defective work, the terms of any order, whether the builder is willing to return, and whether such an order would support a timely and cost-effective resolution of the dispute. In another case of Nationwide Builders and Leroy, which was a New South Wales civil and administrative decision, the tribunal found that the statement by Justice Ball in a case of the owners of Strata Plan 764 versus de Blasio Constructions, that is also relevant to deciding whether or not to make an work order, is as follows. The question of what is reasonable depends on all the circumstances of the particular case. One relevant factor is what attempts the builder has made to repair the defects in the past, and whether, in light of the builder's conduct, the owner has reasonably lost confidence in the willingness and ability of the builder to do the work. So one of the salient aspects of that test and the exercise of a court or tribunal's discretion is convincing the court that the builder is simply not competent to perform the rectification. So in briefing your expert, if you're able to point the expert to situations in which the builder has returned and made attempts to rectify the relevant defects and failed miserably, that's something that the expert could include in his report in an objective manner to use as objective evidence to support the proposition that a work order is simply not going to achieve the desired result, which is having the defects rectified for the homeowner. And in many cases, most clients that wish to start building proceedings usually say to me, I'm over this builder, I don't want to see their face again, and I just want to check to be able to apply to fixing my defects. And that is now the hurdle that has to be jumped across in able to achieve that end. So just to think about how an expert might assist in getting that little bit of extra evidence that you might need on top of evidence about your own, the homeowner's experiences with the builder and the relationship breakdown and the other criteria that come into play in the exercise of the court discretion. Now, that's just another little aspect to think about in terms of how your expert may be used in a way that is perhaps a little less conventional you may not have thought of. So I wanted to finally and quickly take you through the tale of an overbearing client. I was involved in the district court in a case which exemplifies the importance of the expert's role in building cases and the need for experts to adhere to the code of conduct for experts and uphold the code vigilantly and consistently. In this case, we were acting for the defendant, and the plaintiff were a husband and wife owners of a high-end property launching a claim for $800,000 worth of defects. One of the plaintiffs, and I'm not prepared to say which one, was extremely bossy and a headstrong individual who was obviously very used to getting his or her way. So usually when reviewing the work of experts and looking at a draft report, questions like, could this conclusion be more fully reasoned, or could you please add another paragraph to explain exactly why the items are defective? The normal way of looking at expert reports in draft form until you make the changes, and the expert obviously has to make those changes on their own assessment to achieve the final report. Neutral propositions that an expert can take on board or readily reject. In this case, we discovered the opposing party's draft expert report in a bundle of materials served by the plaintiff's solicitors as an annexure to an affidavit, when they clearly intended to put the finalised expert report to that affidavit. And instead of the handwritten comments which you would normally expect to direct to the expert being neutral and questioning in nature, the comments that I've set out in the slide are actual comments that were written in pen across this draft expert's report by the overbearing client. Take this out. Other comments, no way, exclamation mark. Other comments, the retaining wall is in the wrong spot. The surveyor actually got it wrong. And another comment, this is defective. Find a reason in that fancy manual of standards and tolerances, which you have charged me $5,000 to pick over. So unbeknownst to the opposing party, that expert report sat in the affidavit, and naturally when the barrister was finished in cross-examination, the presiding judge was far from impressed and rejected that expert's evidence entirely, thereby rejecting all but a nominal sum of the claim for $800,000 odd. So possibly that's the best example I can give of the important role that experts play in the conduct of building cases. And no doubt Mark will take you into greater depth on some of the nitty gritty and more important and in-depth assessment of the role that our experts play in our cases. So thank you for that. And if we have some time for some questions, I'll be happy to answer any.